So it's my pleasure, and you're in a treat, for me to introduce Andy Brennan. He is a proud graduate of Moritz College of Law at The Ohio State University. He's an attorney at Disability Rights Ohio, where he provides legal advice and advocacy to people with disabilities for the past 9 years. His expertise is in guardianship and supplemental supported decision-making, In the past, he has advocated for people with disabilities in jail and in prison. I'd like to recommend that if any of you have any questions, put them in the Q&A or the chat box, and we'll entertain them at the end of the presentation. In addition, this presentation is recorded along with his PowerPoint. And in about a week to a week and a half, if you get on our website, again, autismakron.org, it'll be there for you to share or to sit at your leisure to look at. So now I would like to I know I did that. I'd like to introduce Andy. Go right ahead.
Okay. Thank you, Wendy. Give me just a moment to pull up my presentation. And share it with all of you. Okay. So yes, my name is Andy Brennan. I work at Disability Rights Ohio. We're located in Columbus, but we serve the whole state of Ohio for a variety of topics that people with disabilities run into and have questions about. Here's a bit of what we do. We give out a lot of information, resources. We make some resources. Legal advocacy, we do investigations of abuse and neglect. We monitor facilities to make sure they're taking care of people with disabilities there. And we try to influence policy to make the state better for people with disabilities. These are some of the teams we have. I also want to point out about the rep payee team. We'll talk probably a little bit about rep payees today, but I'm on the rep payee team now. So a rep payee is someone that manages another person's Social Security money because they can't manage it themselves. If you come across any problems or hear about payees not doing their job, you can refer those to us. Okay. So why are we here? I've done several of these guardianship presentations. Usually the questions are, how do you help an adult who has trouble making decisions for themselves? And what if something happens to my loved one? Who can step in to fix it after they're 18? Who will doctors, landlords, banks, and other organizations still talk to if my loved one needs help? And another one is, what will happen to my loved one if I'm not able to help them anymore? If I become unable to help them, can somebody else? So making decisions for themselves, is guardianship the only way to help? The answer is in most cases, no. So many people with disabilities do not have or need guardians. And there are other alternatives to guardianship that are less restrictive and may even be easier. But what we hear a lot is that organizations like schools or hospitals will sometimes suggest guardianship even when it's not needed, because that's kind of the big one that everyone knows about, and it's the easiest to understand maybe. But it's not always the easiest one to implement or the easiest one to have set up for your family. And we'll talk a bit about what the different options are. So some basic principles here. Everyone needs help to make decisions. When my car gets broken, I take it to a mechanic because I don't know how to fix a car. When my family and I wanted to buy a new house, I talked to my parents. I got their advice and had them look at the house with us to make sure that it seemed like a good deal before I did it. I got help with those decisions, even as a 40-year-old lawyer. And everyone should be allowed to make mistakes and learn from them. If you have ever made a mistake, raise your hand. Everyone's hand should be raised. If you've ever learned from your mistakes, raise your hand. Again, all hands should be raised. If your mistakes have helped shape you as a person, raise your hand. But a lot of times people with disabilities aren't given those same rights that you and I get. And in my work, I often see families or staff or caregivers or guardians put restrictions in place so that an individual in their care can't make a mistake. Often we do it with good intentions because we don't want to see them hurt or sick or sad. But in taking away their right to make a mistake, we are also sometimes taking away a part of what makes them human and what makes their life their own. Now, I'm not suggesting that we throw caution to the wind and let all hell break loose. But a good rule of thumb is ask yourselves, is a non-disabled person allowed to do something? If you had a stressful day at work and you decide to eat a box of donuts, you're allowed to. You're still allowed to eat a box of donuts even if your doctor advises you against it. You're still allowed to eat a box of donuts even if you should be saving your money for something different. You're allowed to make that mistake. So sometimes it's good to ask, would a non-disabled person be allowed to do this? Like, would a non-disabled person be allowed to drink lots of soda instead of water? Yes. Would they be allowed to get a tattoo? Would they be allowed to buy lottery tickets, get a piercing, or skip their medication, or pick who they want to date, or date someone their parents don't like, or have a messy room? These are all things that we get to do that people with disabilities should get to do too. So before choosing guardianship or the alternatives, the best advice I have is to assess the areas in which the person needs support when making decisions. So there are many different ways that we can support a person in making good decisions in their life. Now, the law says that we should start with the least restrictive options before moving on to more restrictive ones. The assessment is different for every person and every circumstance that that person is in. How capable is that person? What is their support circle like? Who's around them that can help them? How much money does your family have or that person? Deciding what their needs are is going to be very specific to who that person is. And we'll talk more about these throughout the presentation, but I like to show this to show some of the variety of different ways you can help people with decisions. So these are daily decisions, what a guardian of the person would do. But guardian of the person is the most restrictive way to help a person make those decisions. Daily decisions would be things like where you live, what medical care you need, whether you're allowed to drive, what sort of things you buy at the store, things like that. So we always encourage people to start with the least restrictive first, and then work your way down depending on what that person's needs are and what their circumstances are. And here's another one for financial decisions. Some people just need informal support and assistance. They just need someone that they can ask questions to, and then they can handle the money themselves. Other people need more help than that. A guardianship of the estate should be the last resort. It should be the last thing you try before looking at all the other options. Now, why do we consider some of these alternatives to guardianship? guardianship can be difficult to terminate. It gets the court involved in your life. You have to submit things to the court on an annual basis. It doesn't happen that often, but sometimes the court orders a guardian to do something that the guardian wouldn't have wanted to do themselves. I have had a client in the past where the person with the disability had two parents that were divorced and didn't get along. And the court said, you know, you two can't work together, so I'm going to make this random attorney the guardian instead. I don't think you guys can be the guardian. And then they kind of lost control of their kid's life. And the court kind of ordered them to do some things that they wouldn't have wanted to do themselves. But most importantly, research shows better health, better safety, independence, integration, employment, wages, and even longevity for people with greater self-determination. People want to have control over their own lives. They want to feel like they're the ones making their own decisions. I think that, you know, any one of us in this room, if, you know, suddenly someone else came into our lives and said, you might like where you're living, but I've decided you're going to move somewhere else and you don't really have a choice anymore. Or you might want to get this medical procedure, but I think that we're going to do it differently, and I think that it's not your decision anymore. That kind of takes away our personhood, and as humans, we don't like that. So there's better outcomes when people get to make their own decisions as much as they can. So, like I said, the first step I recommend is assessing a person's capacity. So I provided to Wendy a handout. Sometimes we call it the stoplight decision-making tool. But what it does is, you know, guardianship often is this all or nothing thing where we think, oh, can the person make decisions themselves? Yes or no. But that's not really nuanced enough, because there's lots of different decisions in a person's life, and most people can make some decisions, but not others. So this chart breaks down all the different decisions and asks whether this person can make that decision themselves, whether they could make it with a little bit of help, or whether they can't make it at all and need a guardian for that decision. So there's different types of decisions that it talks about, like health and nutrition, relationships, personal safety, employment, finances, housing, and living situation. So it kind of breaks all those down into a number of different decisions so that you can think about them as they apply to your particular loved one's situation. So I kind of talked about that on the last slide, but the decision-making assessment breaks that apart so you can consider what the person can do on their own and how much help they really need for each of those different decisions. When to start? It's, you know, it's always a good idea to plan early. This is kind of like a, it's almost like a end of life decision, because, you know, my family, I have a will. I'm, you know, pretty young, but I still have a will for my family, and I have advance directives. That's something I recommend for everyone. To start planning early, because you never know what might happen, and you want to, you know, take care of your family and your loved ones. So you assess which areas they need help and consider how to get that help for them, and then revisit that every few years. So what I do want to recommend is you can call my office. You can call Disability Rights Ohio to discuss some of these options. Just to note, we do take direction from the person with the disability. They're our clients. We're the protection and advocacy system for people with disabilities. So if a parent calls our office and says, hey, I want to talk about guardianship, the first thing we'll usually say is, sure, can we talk to your person with a disability first and get their permission and find out what it is, what their goals are and what they want to achieve. But if they say, yeah, I want you to talk to my mom or my dad, and maybe they want to be on the call too, but we can talk about the different options and we can kind of assess it based on your situation. We can help you go through the decision-making tool and how that works. We can, talk about who's in your support circle and what's your living situation like, or are there any medical concerns that are complicated? We can kind of ask you those questions and give you some idea of what your different options might be for helping the person make decisions. This is kind of a flow chart that I made. I don't know if I'll go through the whole thing, but it's in the slides, and I encourage you to look at it. But what it does is talk about looking at what the person needs help with and whether less restrictive alternatives can help them. And if none of those other options work, then guardianship might be the best choice for that situation. So what is a guardianship? In Ohio, it's when a county probate court determines that a person's legally incompetent, which means they're unable to take care of themselves or their property. And then the court appoints another person to make decisions for them. Some terms that you will want to know: guardian of the estate is a guardian that makes decisions about finances and property. Guardian of the person makes decisions about medical care, housing, food, clothing, shopping, safety. In a lot of cases, a guardian will have both of those. They'll be a guardian of the person and estate. An emergency guardian is one that's appointed more quickly because there's some sort of emergency. Like if a person, got in a car accident and suddenly went into a coma, but medical decisions needed to be made, then their family could apply for an emergency guardianship to try to get it moving really quickly. Co-guardians are when two people are a guardian, like a mother and a father together. A limited guardianship is when, instead of the guardian making decisions about everything from A to Z, they only make decisions about the few areas where the person needs help. So maybe they only need a guardian for medical care, but they can make all the other decisions themselves. Or maybe a person only needs help making sure that they have a good housing situation, but after that, they can live their own life and make their own decisions. So the general duty of a guardian is to make decisions in the ward's best interest. And that's defined in the courts as maximizing what is best for the ward, including the least intrusive, most normalizing, least restrictive decision that's appropriate to their needs. Now that all sounds kind of complicated, so I like to show this little graphic, the best interest balance. Basically, guardian's job is to balance what's best for the person, what keeps them safe, what keeps them healthy, what keeps their finances secure. But they also have to balance that with letting the person have as much independence as they can and the least restrictive life that they can, and to have as much self-determination as they can. Now, different people have different abilities and capabilities when it comes to independence and self-determination. Some people can make almost no decisions. Some people can't make any decisions. If a person's in a coma, they can't make any decisions at all. But most people have some ability, whether it's just choosing what they want to have for breakfast or what clothes they want to buy at the store, going on up to, other people can make decisions about where they want to live and where they want to work. And so in any guardianship, you have to balance what that person's capable of doing on their own and what decisions they can make on their own with what their needs are and what will keep them safe and healthy and secure. What we sometimes see, unfortunately, is guardians only focusing on the part that keeps people safe and healthy and secure, but not always listening to what the ward wants and not letting them live the life that they want very much. And what it ends up happening is that the person, they're safe, but they're also overly protected, and they don't have that dignity of risk to live their own life and possibly make mistakes that they can learn from. Other guardian responsibilities, I'm not going to read through all of these, but they're here in the slides. There's rules that guardians have to follow, and the courts are supposed to be supervising the guardianship and making sure that the guardian's doing a good job. A question that I get a lot at these presentations is, can the guardian be liable if something bad happens to the ward, or if the ward causes something bad to happen? Can the guardian be held responsible? And my best interpretation or understanding of the law is that if the guardian acts in good faith and with ordinary prudence and care and diligence, then they should not be held accountable for losses happening to or from their ward. So you have to do a good job and be diligent and do things in good faith. And bad things can still happen to people, and as long as you're doing a good job and doing your best and acting with ordinary prudence and diligence, the guardian shouldn't be held responsible for that. So guardianship happens at the probate court. How is it started? The person who wants to be the guardian fills out an application packet at the county probate court where the ward lives, or the prospective ward, they call it, because they're not a ward yet. They fill out the application packet. They have to get a guardian background check. There's a filing fee. If you can't afford the filing fee, you can ask for that to be waived. And you also have to get an expert evaluation from a doctor or a psychologist that's within the last 90 days, where the doctor or psychologist agrees that the person needs a guardian and can't make their own decisions or can't take care of themselves or their property. The court schedules a hearing date. That kind of depends on how busy the court is and how quickly all the paperwork gets turned in. A court investigator visits the proposed ward. When they meet, the court investigator provides notice to the ward, tells them that someone has applied to be their guardian if they don't already know it, and also reports back to the court whether the court investigator, whether it appears like the person might need a guardian or not. A lot of guardianships are not contested, meaning everyone's on board with it. Sometimes even the person with, often even the person with the disability, and they're okay with the guardianship, and that makes things a little smoother. If the ward does not want a guardian, or if someone else in their life doesn't think that they need a guardian, those people can also show up to the court hearing and give evidence showing that they don't think that the person needs a guardian. At the hearing, the court's main questions are, does the individual meet the legal standard of incompetence? Meaning, are they unable to take care of themselves or their property? Is the person who applied to be a guardian a good choice? And they should consider evidence of less restrictive alternatives if the person could get help a different way. If the court agrees and appoints the guardian, they will issue what are called letters of guardianship. And the letters of guardianship, the guardian will want to keep, make a bunch of copies of those. And that's what you show to people to say, yes, I am officially this person's guardian. You can talk to me. I can make their decisions for them. I have the letters of guardianship here. Guardians might have education requirements. It depends on your county. I know in Cincinnati, they waive it for family members, so they don't have to do the education, but I think most places you still do have to, it's usually just watching a video online, maybe 1 or 2 hours long, that goes over what the guardian's responsibilities are and what the ward's rights are. After that, you have to submit annual reports and information to the court about the ward and their property and things like that. And the ward also has a right 1 time per year to try to end the guardianship if they don't want it. And if they want to end the guardianship, the court, they also have a right to a lawyer and a independent expert evaluation if the person requests it. So guardianship doesn't remove all the rights from the ward. There's still some things that they get to do under basically like the Constitution and civil rights laws. I'm not going to read through all these, but here's a list in our slides. Some ones that not everyone knows about: a ward still has a right to get married, to decide whether or not to have children. They have a right to drive. They definitely have a right to vote, to have access to their information. They have a right to ask questions to their guardian and have the guardian answer them, and look over their medical records themselves and other information like that. And they have a right to try to end the guardianship if they don't think they need a guardian. And they have a right to file complaints to the probate court against their guardian if they think the guardian's not making the right decisions for them. I mentioned people with guardians still have the right to vote. Guardians cannot vote on behalf of wards, and the guardians cannot tell the wards how to vote. It's the ward's own choice. And anyone with a disability can receive assistance with voting, and assisted technology should be available at all the voting sites. Okay, so I'm going to talk now a bit about these other options, the continuum of supports that we call it. But I know it's a lot to keep in your head all at one time. So I do recommend, give Disability Rights Ohio a call if you have questions about your family's situation, or what some of these different options mean and what are the pros and cons and how they fit into your family's situation. But I will go over them. There's many different options to support a person making decisions. The easiest way is informal support. It's just, what we all do. Asking questions to people and providing them with information in a form that they can understand. You can set a person up with assistive technology, like, if a person needs help remembering to take their medications, you can get an app on their phone that reminds them to take their medications and tells them which ones to take. You can set it up with the pharmacy so that, the pills that they need for each day come in a little packet for each day, so that there's no question they're taking the right ones. You don't have to get a guardianship for everything, or even a power of attorney. You can sometimes just figure out a way to give that person a little help, and that could be enough depending on the person's needs. Supported decision-making is something, so probably I'm guessing most of you are familiar with the IEP process in schools for special education, or the ISP process for the county DD boards. It's kind of a formalized plan for how to support this person making their decisions. It identifies who their supporters are and what their areas of needs are. And it kind of puts down in writing, like, you know, what this person's goals are, what they need help with, who's going to give that help. And it can change and evolve over time depending on how the person grows or what their wants or needs change. And it can be very formal or very informal. You could also just, you know, write down on a piece of paper, like, you know, here's the people you go to if you have questions about your medical care. Here's the people you go to if you have questions about your finances. That's supported decision-making, kind of an informal version. You can also do it very formally and have meetings on a regular basis. You can decide how often that's needed. You know, it could be once a month, or, you know, a few times a year, or just whenever it's needed, but not all the time. You know, it can be a real formal process where you have certain people show up to the meetings and everyone has a job and they check in with the person. You know, it kind of depends on the person's situation. There are some sample supported decision-making plans available. So like this one that I have on the slide, it says, my supporter does not make decisions for me, but to help me make decisions, my supporter may help me get the information I need, help me understand my choices, and help me communicate my decision to the right people. So supported decision-making is giving the person the help they need, giving it to them in a way they can understand, but it's still their decision. And they get to make that choice, and you can help them make that choice. Sometimes we hear that people are, you know, they say, oh, I went to the doctor and they wouldn't give me the medical records because, you know, my son or daughter is over 18, so they wouldn't let me see the medical records. Well, you don't need a guardianship to see medical records. You just need a release form. And likewise, you know, if you wanted to call Social Security and ask questions about your son or daughter, you don't need to be a guardian to do that, but you do need to fill out a form to make yourself an authorized representative. So sometimes there's just basically a permission slip that the person with a disability can sign that says, oh yeah, I want my mom or dad to be able to talk to Social Security or to my doctor or to the hospitals. And sometimes it's just a matter of finding the right form. And you don't need a guardianship for that. Sometimes people think that a guardianship is necessary because they're concerned about a person's safety. If someone is, you know, threatening or being dangerous to a person, you don't necessarily need a guardianship to keep that person safe. Sometimes you could just get a protection order, you know, a no contact order, as you know people call it, that a court gets involved and says to the, you know, the threatening person, you have to stay away from this person, and if you come close to them, then they can call the police and you can be arrested. So trusts are basically, I like to think of it in simple terms as a bank account with rules attached to it. And a trustee makes sure that the money is used according to the rules on the bank account. It's a bit more complicated than that, but it's a way to make sure that a person with, it's one way that you can make sure a person with disabilities has enough money, and that there's someone else helping them spend that money and make sure that, you know, they are provided for, even if they lose their money themselves. So a power of attorney, there's two main types: financial power of attorney, healthcare power of attorney. A financial power of attorney can help a person make decisions about their finances. And the difference between a financial power of attorney and a guardianship of the estate is that the financial power of attorney should still be, trying to achieve the goals that the person with the disability wants. So it's still the person with the disability's decision, but once they make that decision, the financial power of attorney can go to the banks and can access their money and whatever is necessary to help them fulfill those duties, to help them to meet their goals. Same with a healthcare power of attorney. The person with the disability, well, and also you don't have to have a disability. You and I can give financial and healthcare power of attorneys to other people too, in case something happens to us. And I actually recommend that. I think everyone should have, they're called advanced directives set up so that if something happens to you or you're not able to make your own decisions, then there's automatically someone you trust who can take over and making decisions for you. And we can do that with powers of attorney. A couple other terms that you might have heard with powers of attorney: a durable power of attorney means that when you sign it, when the person signs it, it's effective now, and then it continues to be effective even if the person loses capacity later on. A springing power of attorney means it's not effective until the person loses capacity. So my wife and I are, our financial power and healthcare powers of attorney for each other, and it's springing. If anything happened to me where I lost capacity, it would spring into effect, and my wife would be able to manage finances for me or make healthcare decisions and give consent for me at the doctor's office. In order to sign a power of attorney, the individual must have an ability to understand what they're signing with support, which varies depending on how complicated the power of attorney is and what that person's abilities to understand. So, if you can explain to a person the different parts of the power of attorney form and say, son or daughter, if something happens to you and you can't make your own decision, do you want mom and dad to be able to make that decision for you? And if they say yes, then they can put their initials on the form and sign it, voluntarily make it so that you are their power of attorney. Power of attorney forms are available online. That's the ones that my family used. We just went and filled them out. If you have a complicated situation or you want legal advice, you can talk to lawyers and get advice on what it all means, and they could even make a special power of attorney for your circumstances that's different than the form ones that are available online. So a representative payee, this is an alternative to a guardianship of the estate. Sometimes if a person, some people, the only income they have is their Social Security money. And really, they don't need a guardianship of the estate. They just need a rep payee to make sure their bills are paid. So a rep payee is a person chosen by Social Security to make sure that the beneficiary's needs are met and that their Social Security benefits money is spent only on them and covers their most important needs like housing, medical care, groceries, clothing, things like that. A rep payee does not have control over non-Social Security funds. So if the person has a job and they get wages, then the person with the disability still gets to control the money that they make from other places that aren't Social Security. And sometimes that's a good arrangement. You know, the rep payee makes sure that their most important needs are met, that their rent is paid, their groceries, and then the person can make their own money from other places like a job and spend that however they want, knowing that they have that safety net of the Social Security money to hopefully cover their most basic needs. Again, Disability Rights has a rep payee review program. So if you hear about a rep payee that might not be doing their job or may even be stealing the money for themselves, give us a call. Disability Rights Ohio might be able to help. Conservatorship is kind of, I don't know anyone that has this. It's an option. I'm not going to read through the whole thing. I kind of like to think of it like a power of attorney that you file at the probate court, and then the probate court supervises it, kind of like a guardianship, but it's still technically voluntary, like a power of attorney is. And if the person wanted to end the person with a disability wanted to end the conservatorship, they could just write into the court and say, I don't want this anymore, and it should go away. That's not quite how you end a guardianship. So it's kind of like a power of attorney that's supervised by the court. Another way to help with the person's finances, this isn't exactly an alternative to guardianship, but we just want to make sure everyone knows about able and stable accounts. This is a special kind of savings account that if a person had their disability before the age of 26, like developmental disabilities or intellectual disabilities, then you can save money up to $14,000 a year without impacting their Social Security or Medicaid or other public benefits eligibility. And it even has some tax benefits. So you just have to, that money can only be used on qualified disability expenses, but that's pretty broad. And it covers things like housing, transportation, assistive technology, education, you know, a lot of things that, you know, everyone needs. So it's a really useful program and a way to save some extra money that doesn't impact public benefits. Okay. So these are some questions that were submitted before the presentation. So I'll try to address those first, and then I'll open it up for any other questions that you might have in the audience. The first question, what if there are no family or living relatives to be a guardian or power of attorney? So this is true for all of us, you know, people without disabilities, people, you and me, all of us. You want to think ahead and early and think through who might be able to help you if you can't make decisions for yourself. If something happens, or if something happens to you, who's going to take care of your kids? Or if something happens to you, what's going to happen to your money? If there is no family or living relatives, you can hire a professional like a lawyer or a social worker or a nurse for personal and medical decisions, or you can hire like a banker or a CPA for financial help, but they'll probably charge you an hourly fee. I'm giving a presentation. Sorry, my daughter. The issue is that they'll, you know, charge a fee for anytime they are working on your case. They're going to charge an hourly fee. There might be some organizations or nonprofits that can help. You could ask your DD board for ideas of organizations that might be willing to be a rep payee or power of attorney. there are even there's something called APSI. There's organizations like APSI and a few others that can even be guardianship for people that don't have anyone. And last but not least, the courts usually have the probate court should have a list of professional guardians that they use. And you know, if a person comes to the court, if a person who needs a guardian appears at the court and there's no one available to be the guardian, the court usually has a list of people that they can assign to be the guardian for people that don't have anyone else. Sometimes the guardians on the court list have lots of wards though, and can only provide minimal supervision. But some of them also do a really great job, so it just depends. Next question, how long does it take to get a guardianship? I've heard 2 to 4 months is common. It can depend a lot on the case. It can take longer if the court is really busy. It can take longer if the guardianship is contested, and some people don't think it's necessary, and it kind of, you know, becomes an argument about whether they need a guardian or not. If there's a complicated financial things or property that need to be worked out, that can make it take longer. If people don't get the right forms in at the right time, that can delay things. If there's an emergency and you need a guardian very quickly, you could try to get an emergency guardianship, and hopefully that, you know, depending on how dire the emergency is, gets done in a week or less. All right, another kid breaking in. All right.
Sorry.
Okay. Sorry, Jess, I'm giving the presentation. Sorry about that. So yeah, I've heard it takes a few months, but it can be quicker or longer depending on the circumstances. Okay, what are the pros and cons of guardianship and power of attorney for the caregiver and the person with autism? Can limited guardianship be used instead of power of attorney? What would be the advantages and disadvantages? So I hope that we kind of covered that in the presentation. There's different advantages and disadvantages for all of the different alternatives. And I really think it just kind of depends on your family's situation and what the person with the disability's capabilities are. And so that's why I kind of recommend, you know, if you want to talk through the different options and see what might fit with your family, call Disability Rights Ohio, and we can try to talk through that with you and figure out, you know, how it works for your family. It's kind of like, you know, when you're making investments, like, do I put my money in stocks, or do I put them in bonds, or do I put them in real estate? There's different pros and cons to all of them, and it just kind of depends on what your goals are and what your situation is. So it's really best to just talk through it with someone. Does shared parenting or divorce play a role in guardianship? So it can. So if a person applies to be guardian, the court has to decide who's the best person, you know, is the person who applied a good choice to be guardian? And if there's, you know, shared parenting, the court has to figure out what's in the best interest of the ward. And, you know, is it going to work out? Do we need to make both parents co-guardians? Or do we just need to pick one that we think will do the better job? Or sometimes the court says, you know what, these two parents don't get along. They are fighting about things and they have disagreements. I think we need to make a third party, you know, someone that's outside of the family, a guardian instead. So that can play a role. The court just has to decide, you know, what's going to be best for this person and who's going to be the best choice for guardian. Can you please address successor guardians? Okay. So yeah, successor guardians, the way it works is if a guardianship is already in place, there is a way that you can nominate someone to take over as guardian if something happens to the guardian. It's called a guardian nomination, and it's kind of like there is a process for it. You have to have two witnesses or a notary to see you sign it, and then you submit it to the court, and it's put into the guardianship docket, and then the court knows if anything happens to the current guardian, this was someone that was nominated to take over. Now it's still going to be the court's decision, and they're going to look at that person that was nominated, and they're probably going to say, okay, yeah, that looks fine, let's appoint them as the successor guardian. But they don't have to. If the court thinks that the person that's nominated to take over as successor isn't a good choice, they don't have to follow that, and they could make some other person the guardian instead. Okay. So those are all the questions you had submitted before. Just a few links. We have some guardianship resources on our website. So things like, you know, a person's rights and guardianship and a few things there. So feel free to check out our website. And you can also give me a call or email if you have questions about the presentation. And of course, you can call Disability Rights Ohio, just our normal intake line, if you want to open a case to get more direct help. So.
Thank you, Andy. Or don't you love Zoom, huh? I wanted to share something. As a parent of 4 daughters, my husband and I were working on our will, and we were trying to name guardians for our 4 minor daughters. So something happened to us. And I remember telling a friend of mine, and I hear a lot from callers who tell me, this is just such an emotional decision. To name somebody to be my successor, it's just too emotional. I don't know how to make this decision. And a good friend of mine said, well, it might be a hard decision for you, but it'll be an easy decision for a judge. So I would recommend when the families here are doing their future planning, first of all, this is the end of a series that we just completed. We tackled SSI and SSDI, how to help someone with a disability grieve when their caregiver or a parent passes away, the guardianship. And there's also a presentation on My Care, combined Medicare and Medicaid program for people who are over the age of 65, but are also disabled and drawing Medicaid. So I'd recommend, especially with all of this series now done, that you sit down as a family and make some of these decisions now when the information's in front of you. Okay, we have a few questions. Andy, my son is low functioning autism, fully nonverbal. I'll have to take the guardianship over for him. He's turning 17 this fall. When is a good time to start the process?
So as far as like, you know, thinking ahead and planning, you can definitely start now. As far as like turning in the court forms, so you won't be able to start a guardianship until a person's 18th birthday. And you have to get the doctor's evaluation within 90 days of the application. So you can, you know, look at the forms and start filling them out and think ahead and talk to other, you know, professionals to get help. But as far as turning in the forms, like, you know, 90 days before his birthday, go see a doctor, get that evaluation filled out, and then you can turn in the forms within 90 days of their birthday, I guess.
Okay.
They won't start the guardianship until after the 18th birthday, but I think you can call your court and ask how they handle it. I've heard some courts will say, if you turn in all the forms before their birthday, then we can have the hearing like very soon after their birthday to make sure that it happens quickly.
Tiffany asks, I have twin sons with disabilities. How would I best deal with both needs at age 18? And when should I apply? I think you answered that one with the last question. But how would she deal with both needs of both children?
Well, I think that might be something that you spend the next 6 years thinking about. And again, it depends on what their capabilities are and what the family circumstances are, who might be around to help them, if they have complex medical needs. So there is a lot that it depends on. So that might be one that you could call to get some, call Disability Rights Ohio or start talking to, people at the DD board and planning ahead for, and, revisiting over time. So.
Again, where do you find the guardianship application?
So it's always going to be at the county probate court. You're supposed to get guardianship in the probate court where the ward resides. So where the person with the person who's going to be the ward lives, that county. A lot of the county probate courts have things online. They have good websites, and you can just click around to find the forms, and then you can find the guardianship application packet. Some smaller courts or more rural courts might not have a good website, and then you just have to go into the court, or maybe you could call them and ask them to mail it to you or something.
At what age can a ward begin making his or her own decisions, which means they're out of parental control?
So yeah, a person becomes their own guardian when they turn 18. That's just kind of the legal standard. So yeah, on their 18th birthday, they can technically make their own decisions.
So I've also spoken to families whose 18-year-olds are going to stay in public school system to age 22, and they're sitting down for IEP meetings, and parental control of all the disability services through the school ends at 18. And the kid gets up and walks out. I don't want to do this anymore. So another reason to have something in place. If
Yeah.
I'm sorry, go ahead.
No, yeah, that's true. But also, you don't absolutely have to be a guardian to continue to participate in IEP meetings after the person turns 18.
Mm-hmm.
The person with the disability can just say, yeah, I agree, my mom can be here, my dad can be here and help, and continue to participate in the discussions. So you don't have to be a guardian of the person to keep going to those meetings.
Right.
But if the person who's 18 doesn't want you there, then yeah, once they turn 18, that is their choice.
Or if they don't want to do that anymore, they have that right, I guess, to stand up and refuse it. Yeah. Mm-hmm. Is a guardianship recognized nationally?
Yeah, yeah. So, I mean, it's an interesting question. Like, if you are, I might need to know like what you mean by that. Like, do you mean if you call Social Security, which is a federal program, and say I'm the guardian, will they still talk to you even though they're in Virginia or whatever? Yes, they will. They recognize the state guardianship. If you and your ward moved to a different state, though, you would have to transfer the guardianship over to that other state. And their rules might be slightly different in other states too.
If I am a guardian for my adult child already, do I still need power of attorneys?
No. Well, so if you're a guardian of the person, then you don't need a healthcare power of attorney. If you're guardian of the estate, then you don't need a financial power of attorney. If a person has a guardianship, then it negates any power of attorneys that they might have had before that.
Does the guardian need to show proof every year of the money spent throughout the year for the ward?
So if you're a guardian of the estate, there are rules about you have to keep track of how the money's spent, and I do think it's either every 1 or possibly every 2 years you have to submit that to the court. It kind of depends on the court how detailed and specific they want you to be. Like, I think a court could say, like, enter the amount of money you've spent on their housing, and you can just kind of put, oh, their rent was about $500 a month, so I can put, whatever 12 times $500 is, but other ones will want you to turn in all your bank statements and keep receipts, and they probably want you to keep all that in case any problems arise. They want you to be keeping those records and details and receipts and copies of bills, just in case something goes wrong. But it's kind of up to the court what they want you to turn in every year. And you can call up your probate court anytime and ask them, like, what kind of things, if I became a guardian of the estate here, what kind of things would you want me to turn in every year? Can you show me a copy of the annual accounting form I would need to fill out? So you can kind of do a little research beforehand and talk to your court and ask them how they handle that.
The last question is several questions. Is there a paper that the ward shows people so that they know that they need to involve the guardian or power of attorney? How are the guardians or power of attorneys included in decisions, especially when the wards are not good communicators?
So when the guardianship is established, the court will give letters of guardianship to the guardians, and those are the papers that the guardian or the ward could show to someone else to say, this person has a guardian and it's me. If someone just went up to your ward on the street and started asking them to, make decisions or sign a contract for a lease on an apartment that they can't afford or something, and the ward never told them that they had a guardian, then the guardian could cancel that decision and cancel the contract and say, look, I'm sorry, you didn't know that this person had a guardian, but they're not actually able to make that decision themselves. You had to talk to me. So does that make sense?
Yes. Yes.
But I guess the letters of guardianship would be the papers that you show to people.
Okay, the last question then will be, what kind of accounting do you need to show for powers of attorney?
That's a good question. I don't know if it's necessarily required. A power of attorney, well, I don't want to give the wrong answer. It's definitely less formal than a guardianship of the estate. I think that it's a good idea. Anytime you're managing money for another person, I think it's a good idea to keep records and bank statements and to have it in its own separate account. This is true for rep payees too. If you're a rep payee, a power of attorney, guardianship of the estate, literally anytime you're taking care of someone else's money, you really want to keep pretty good records. You want to have all the bank statements, keep copies of receipts, especially for big purchases, to keep copies of the bills you're paying, the checks that you write, so if anything goes wrong and anyone, points a finger of blame at you, you have the documentation to show that you did a good job and you were doing it right. I don't know if it's required for a power of attorney, but I think it's certainly a best practice, and you could get into trouble potentially if you didn't have it and someone accused you of doing something wrong.
Mhm. Okay, Andy, thank you so much for your expertise on this topic. All of the PowerPoint and presentation will be ready and on our website within a week and a half to 2 weeks. So look for it there. Tomorrow, I will email out the that handout that you gave us, Andy. What was it? The one where your the assessment?
Yeah, the decision-making checklist. Yeah.
I'll email everybody that assessment sheet tomorrow. And if you have any more questions for Andy, there's the slide up right now. You can contact him at Disability Rights Ohio. Thank you. You have a good evening, Andy, and everybody out there. Thank you so much.
Thank you. Thanks, everyone. Bye-bye.